And I think we're live. So hello, everyone. Welcome to the Health Insurance Protection Act webinar on how you should build data stacks that are compliant with this law. We have here Steffi, who is a European GDPR and contract lawyer, data protection officer, and can tell us all about these topics. So Steffi, would you like to introduce yourself and take it from here?
Yeah, thank you for having me. Hi, everyone. My name is Steffi. I am a European GDPR lawyer, actually, working in GDPR and contracts. I provide mostly my consultation services to startups and small and medium companies, mostly in the area of health. In Europe, my clients currently are based around Finland, Estonia, Germany, Netherlands, Denmark. And before coming to Finland, I also worked and lived for around 5 years in Boston. So I do have some experience also with the US court system, but that was from another angle. So today I will focus on the HIPAA requirements that are necessary by law so that European companies are not going bankrupt under potential HIPAA fines. Put questions in the chat and I'll try to answer them as much as I can. And thank you for being here. Let's get started. So if you've been familiar, if you attended the webinar or seen it from last week on GDPR, you see the format may seem familiar to you. I'm going to keep it rarely similar to understand what's the scope of HIPAA, data use, data types, subject rights, what is considered safe and secure data, and a data breach. So this to make sure that we understand from both laws what we can do or what we need to do extra to comply with both of those regulations. The HIPAA stands for Health Insurance Portability and Accountability Act. It is the privacy rule, it has the HIPAA security rule, and it has the HIPAA breach notification. In general, to make it clear, in the United States, lawmaking power is shared between national and state governments. And where the federal legislative branch has not made a law, the states can actually make their own laws. So federal laws also point out where states specifically cannot deviate from laws. But all in all, the HIPAA is a little bit confusing as well in regards, or data privacy is confusing in regards, because you end up with federal laws, state law specific rules, regulations issued by agency, and it can intertwine and work together. So concerning HIPAA only, it's about the protection of personal health information in the medical field. And you may also have come across the HITAG Act, which is similar, or like connected, but not the same. And that organizes security features and protections of, so to say, the health IT. So for the systems in the US healthcare system. So today we're going to focus on HIPAA only, the first part. The scope of HIPAA, as I said, it's a federal law, so it's complied to the entire US, but states can make stricter laws. It is about the protecting of a type of personal data, such as health information. But the interesting catch is that it applies to entities that are HIPAA entities, so to say, which are covered entities or business associate, such as the covered entities are healthcare providers, healthcare plans, healthcare clearinghouses, such as anyone hosting or handling or processing medical information. With other words, if you are, for example, if you're having a fitness app and you have not worked with this information under medical or receiving on behalf of a medical covered entity, a medical provider, etc., but you have opened up this fitness app and someone is providing you this health information, you do not need to comply to HIPAA rules. To say that this is different in GDPR, because in HIPAA rules, the entity must be covered by HIPAA. So yeah, you're a covered entity or a business associate. which I will go later deeper in about, the states may make stricter rules, such as data breach notification requirements are a bit stricter or different in different states. And there can be security requirements, data subject notifications, etc. Whereas in the GDPR rules, it's about health data, full stop. If you process health data, you need to secure this extra. It doesn't matter if you're a freelance developer or if you are a company or hospital, a research institute. Health data is health data. They look merely to the type of data. And then you always need to show that you have secured it properly. Now, EU member states can make additional rules related to the areas that GDPR said you can. So they cannot always make stricter rules or not stricter rules. They can, it's related to the type of areas that GDPR has allowed. Now, a few of those are, for example, employee data, medical research, or children consent age. Some interesting definitions that I want to get into. So first I should try to spell that right. Let me send you the right slides with the best spelling. So under HIPAA, what is often being said is, oh, I have PII or PHI. Now, PII is personal identifiable data, but in different US laws, there's no broad US law defined personal data. There is a broad definition, a concept, whereas GDPR has very specifically said all data related to an individual is personal data. This is very different because under HIPAA, not only under HIPAA, under other laws, personal data can sometimes be defined very specifically or conceptually. Now, the PHI that is also mentioned is protected health information under HIPAA. And that means that it is from covered entities falling under the HIPAA rules. And this means it could also cover publicly available data. This is the same in, of course, in GDPR, where special category data is, of course, also includes any data related to health. And it doesn't matter if you have published it online or not. People should still have specific authorization of using health data. You cannot just scroll or like crawl or scrape a website full of health information, start to make build profiles and the like. Then in GDPR, we speak about pseudonymization and anonymization, whereas in US laws, we speak about quasi-identifiers, direct identifiers, quasi-identifiers, and de-identified data. And de-identified data is what people would understand in the US. Like, okay, that is data that we understand in GDPR is anonymous. So no link can be made anymore between the person and the data. As I said before, HIPAA has specific roles that the rules apply to. And one is the covered entity, so anyone needing to comply with this law, and those consist of the healthcare providers, the health plans, and the healthcare clearinghouses. And then the business associates is anyone not part of the covered entity's workforce, but processing, storing, handling the personal health information on behalf of the covered entity. The person is an entity with legal rights, and we know that in GDPR, it can be actually also data processor, data subject, and an authority for HIPAA is primarily the US Department of Health and Human Services. However, also other agencies that will come clear later on, other agencies can actually pose fines, not under HIPAA, but where it contains health information. In Europe, you have an authority in each and every European member state, the data protection authorities, and they can pose fines, they can start investigations, as well as any individual can go to a national court. The types of data is interesting, as I said before. So under GDPR, it's very broadly defined. Personal data, direct, from last week, you remember probably, direct identifiers, indirect identifiers. It's very broadly defined, and all the way up until including pseudonymized data is still personal data. And then part of this data is data related to health. And as soon as you have this data, you have to secure it and show that you've had the security measures in place. Whereas under HIPAA, you have, first of all, personal identifiable information, such as information in paper or electronic on its own when combined. This is often, this type of data on the right is what most of the states always see as personal data. They have mentioned it, but then there's also additional elements that can be personal data. Now, then under HIPAA, you have specifically the PHI, right? And that includes any information that can be linked to a health status, healthcare payment, healthcare service, medical records, test results, treatment plans, etc. So that is really the same in the end as GDPR, except that they mention many of these identifiers, whereas GDPR leaves it completely open. If you think there is one of the cases that decided what is health data under GDPR is actually a case where a person broke her leg. So all of that is health data in GDPR. In HIPAA, it's health data under HIPAA when it's being processed by the covered entity. It's a major difference. This one I think is also familiar from last time. So what exactly is GDPR data and not? So then in the end, the anonymized data is absolutely no GDPR data. And as I said, the HIPAA data is the direct or quasi-identifiers by covered entities or business associates. And no HIPAA data is de-identified data, or de-identified data for research, or if there's certain exceptions, there's other exceptions where you can potentially use data that could be covered under HIPAA, but you have a possibility to use that. I will go into that in a little bit. So this one is also familiar. Under GDPR anonymous data is any deletion of the secret keys. It must be completely broken, so no information or no link anymore between the original data set and the data subject based on the current state-of-the-art techniques. It's not objective, but based on it's an objective assessment. Sorry, the other way. The assessment should be objective, not like, but we don't know who it is. And it's mostly, you should think of aggregated data. Under HIPAA, I love this one the most because it's so clear. Anonymous data is what does not actually identify an individual, and there's no reasonable basis to believe that the person can be used, that the data can be used to identify a person. At least 18 of this is specifically law, I'm not making this up, at least 8 data elements from the law have been removed. Exactly. Or an expert has certified the risk for identification, that the identification is very small. Why I love this is because as a lawyer, you can base a lot of things on this. And under GDPR anonymous data, it's very difficult to make this assessment, go through the entire 9 yards, as they say in the US. I love that. So this is very clear what means anonymous data. If you remember last week, I came with a case where it said it was very difficult, where a company actually followed this anonymization procedure from the US. And then in Europe, it was said like, well, you still have personal data in Europe. I can completely see, and I think you as well, that under HIPAA, this is such an easy mistake to make. So be careful when you say, I have anonymized data, because under which of the laws do you have that, right? Like this is HIPAA anonymous law. It's not the same as the GDPR anonymous law. Okay, so about this compliance, I put up as a reminder this slide on what are the GDPR compliance principles, which, as you know, like it's a legal basis given clear, informing, and transparent information to the data subject, what data we're using, a specific purpose, don't use more than you need, accuracy. There's a storage limitation. In the systems need to be trustworthy and keep the data confidential, and there needs to be an accountability trail. Under HIPAA, we have the personal. It's also a bit different, as you can see. One thing I like a lot that is here as well is the privacy notice that is always in the compliance principles. Makes it very clear. So you have the personal health authorization for use and disclosure. With other words, information and consent. You have a privacy notice, which is the transparency and fairness. You should not have more than necessary for the purpose. So that purpose limitation is also caught. We have individuals' rights to access and amend, meaning like we can access the data if there is a specific authorization, and we can, they have the right to modify it, and they have the right to restrict the processing. And that we must have safeguards in place, which comes down to the similar one as integrity and confidentiality. So safeguards of making sure the data is not being unauthorized disclosed to someone else. Again, the Chinese walls of access and making sure no one can access unless specifically authorized. And we have the accountability trail as well here in HIPAA. So that is familiar, thankfully. So retention, I took out the key ones that are a little bit different in this compliant concept, so we don't miss them. Under HIPAA, retention is not specifically mentioned. Like in GDPR, remember, we have the storage limitation that everyone is falling about, like don't keep it for longer than necessary. And we have what is necessary and how many years does that mean and how long can I keep it? And everyone is like completely crying about that. But in HIPAA, they solved that by not mentioning it, not making it a compliance issue, at least under medical records. Instead, they gave certain acts and rules, gave specific guidance with number of years that you should keep medical records for, specific tax accountants or specific payment details or disclosures, etc. So instead of saying like we put the burden with the person processing the data and don't keep it for longer than necessary, HIPAA is a bit more accommodative to the processor. The also accuracy is embedded in the safeguard. So there is, of course, the right to make amendments, but in the GDPR principles pretty strong. Like we have to make to give the means to the individual to make inaccurate data accurate is pretty intense. In HIPAA, there is the right to make amendments, but those are also falling under the safeguards, like the system. How is it designed to make data that is inaccurate, accurate, etc. Then there's the data subject is different, where of course it's a natural person, but I already mentioned that, and authorities, I also mentioned that. So legal basis under GDPR, as I said last week, those are very 6 specific rules. Basis. If you don't have one of those 6 bases, please remove your data or fix this, because it's very difficult. If you cannot base the data set that you have in hand on one of those 6 legal bases, you are violating GDPR immediately. So don't try to fix that or try to get the consent of the contract or throw it away and re-ask. Under HIPAA, as I said, you have to disclose use. This disclosed if you have consent. You have you can always use anonymous data. There is no link with the data subject, and as I said, like at least 18 elements. There's no specific legal basis as in GDPR other than access and can I use it, such as authorized use. There is research, person has given consent, so there's always consent, or there is no consent, but then on the research, there must be an institutional review board that has approved the research. The research must be permitted on, again, anonymous or de-identified information and rules. And they must be more flexible only if a limited data set is released to the researchers. So also the amount of data sets is important in under HIPAA, whereas in GDPR, that doesn't matter. That will only matter for a data breach, for example, for assessing how you have secured it, but it never matters for disclosure. For disclosure, it's always personal data is personal data, sensitive data is sensitive data, whereas under HIPAA, there is the data set, the amount of it is being assessed, the anonymization method is assessed. You must have always consent, meaning also for marketing purposes, you cannot use it unless, usually the marketing is an opt-out system in the US, but for HIPAA entities, you always need to have consent. Other exceptions, I mentioned before that there's other exceptions where you can use HIPAA data without consent, and that is for use of public health activities to report victims or abuse, neglect, or domestic violence. The legal system can use it for judicial and administrative proceedings, and certain law enforcement activities can also use HIPAA data without consent or authorized disclosure. And no, again, no, if you're not a covered entity, you can use health data. So not the HIPAA data, but health data. If you're not a covered entity, but a startup starting to provide a wearable, for example, like a Fit Watch or an Apple Watch, collecting health information, as long as it's not linked with medical information, as long as you're not doing this on behalf of another medical provider, you do not follow the HIPAA requirements, and you can follow your business requirements. But make sure that even if you don't follow the HIPAA requirements, such as disclosure, consent, safeguards, privacy notice, etc., there are still other acts. And those are from all of the states where you may process data from where the people are living. And those acts, and one of the major ones is the Federal Trade Commission, which always studies and investigates the unfair and deceptive practices. So soon if you are having health data and it's not being used or it's not covered under HIPAA requirements, it can be covered under the Federal Health Trade Commission. I'm trying to get my, yes. What you always have to give is a transparency or privacy notice. This is one of the requirements as well. So you can use it when you have consent. You have to give a privacy notice. And the privacy notice is still a notice, like in communication towards the person. But if you are providing this to a consumer to use their data in accordance with the terms of the notice, then it could become a contract. So make sure that how you are using data, this works the same under GDPR, right? So how you're using the data, from who are you using data? Are you using it from via the contract as a business associate from the covered entity, or are you using it directly from customers? So who provides the consent and who's providing the privacy notice, and what does the privacy notice mean? What exactly are your responsibilities in that? In GDPR, to make it clear, a privacy notice is never a contract. It's always a notice. No acceptance needs to be obtained. What needs to be obtained is, what needs to be done with a privacy notice is that it needs to be made clear, transparent on the website and always available. But a notice is not an agreement, so it can never be accepted, so to say, as an agreement by the other, by the data subject or the person. This was an interesting case, the Flow Health case. You may have heard about it. It was a fertility tracker or menstruation period tracker. It had around 100 million users, and this company was not covered under HIPAA because it was not an entity, covered entity or business associate. And it promised in their privacy notice not to share data, but then it actually shared data with Facebook via marketing tools. And because they were sharing data, also European subjects were affected because they were sharing data. The Federal Trade Commission started a huge investigation about unfair and deceptive practices because it was not covered under HIPAA. But having a privacy notice that says you will not share it, but then you shared it via tracking methods or marketing methods with Facebook, that can be seen as an unfair and deceptive practice. And they found in the end a settlement with Flow Health. So marketing opt-out is allowed, but you need to be very clear and transparent about what data it is that you're using and sharing. This is the same in all the laws. So about the rules, as you remember, I wanted to put it out here for a second. The GDPR rules are controller and processor, and they have a data processing agreement together. And the controller uses the data within the scope of the consent, and the processor on behalf of the controller. There is a contract. The controller decides the security measures and notifies the breaches, whereas the processor refers back to the controller. Under the HIPAA rules, we have the covered entity on one end and the business associate on the other hand. And they together have a business associate agreement, or in short, a BAA. The covered entity use the same scope of data within their authorized use of consent and disclosure. They must provide the so-called privacy notice. They must conduct a risk analysis and incident response plan, implement the security safeguards, and notify the breaches to authorities and affected individuals. And they must answer data subject rights. And the business associate, actually also similar in GDPR under the data processor, act within scope of the contract, must prove that their security measures are appropriate, and immediately inform the covered entity if there is a data breach and assist with data subject right request. Now, one small note about this, not a very tiny one, or a very tiny one that could result in a very financial huge one, and that is that you will see later, I will go a little bit more into later on that one, but the notification obligations are really expensive. They can get very, very expensive, because a covered entity must inform affected individuals, each and every one of them, and the preferred method is paper, like a post. And they can only send an email to inform about the data breach if the individual has previously consented to that the email is their preferred method of communication. So if that has not been the case, then the covered entity has to send a letter to each and every individual. Now, later about that, but there are a few things in the BAA, as you see. The DPA in the GDPR is very standard. There's often just merely copy-pasted articles from GDPR because GDPR covered that already for us. So it's usually one of the most easiest contracts to read, to see if there's nothing that has been added that is not law. Then we can talk about that, but it can also not conflict the contract. So it's pretty easy. The business associate agreement can have quite some language in it that turns out to be a negotiation, or can have a huge risk for a smaller party. Such as, like, if the covered entity refers all their notification obligations to the business associate. That's possible, and we can do that by contract, but it means that the business associate is then going to have to notify all of the people by mail. And if they are more than thousands, he has to pay for media notification. With those costs are going, they skyrocket. So you can actually bankrupt a company by a wrong or not negotiated contract that has been unfair drafted. As simple as a BAA, which actually is shorter than most of the DPAs. So data subjects, as we call them in GDPR, persons, individuals. In the US, in the US, they are not really called data subjects, or sometimes they are as well. They receive a privacy notice, and any of their rights must be answered in a timely manner. In GDPR, you have 30 days, and there's no negotiation about that. No discussion, 30 days. In HIPAA, it's answered in a timely manner, and a timely manner was something between 30 and 45 days. There has been some states gave some different opinions, but 30 to 45 days was kind of the average. So if everyone stays around the 30 days, we're all pretty safe. Interesting also, perhaps you spotted it, the HIPAA does not explicitly provide the right to be forgotten, which is a huge right in GDPR as well. Like a lot of people, especially in commerce, not under the medical health, well, sometimes under medical health as well, but mostly under commerce, it's a huge right that is being extensively used by people that needed to still pay something, and before they can pay, they start to like, oh, but I also have a right, the GDPR right, that is the right to be forgotten. Please delete all my data. And of course, neither of the laws provide this situation, because you will answer like, well, you do have that right, except under HIPAA, but you cannot exercise it because we still have a legal claim open. Now, under HIPAA, the right doesn't even exist. So it's not a right that specifically is being provided. And the rationale behind it is because medical records need to exist to maintain the trustworthiness and confidentiality, and the data keeping, record keeping, etc. of the medical information. The rest are right to request restrictions. We have the same as objections. Right to access, of course, right to consent, right to be informed, right to request amendments is the right for accuracy, and the right to request, also an interesting one that is not in GDPR, which is the right to request confidential communication. In the medical field in HIPAA, you can exercise this right if possible, but this is not something that exists in GDPR, so that is very that's a nice addition here. Okay, so about the next compliance issue in HIPAA is the security, or safeguards, as they call it, and it comes also close to what GDPR is requesting. So I honestly, if you are able to secure data under GDPR, you're pretty good also under HIPAA, because those security standards are pretty similar. It's about the confidentiality, making sure that there's no unauthorized access, making sure there's availability of the data from anyone that creates or receives or maintains or transmits it. That's an important addition. You protect it against reasonable threats or hazards. So that's a bit different, but I will show you in a little bit. It relates to the also to the data breaches. Protect against reasonable anticipated uses or disclosure, and ensure compliance by the workforce, which is interesting because this is very HIPAA really has been hammering on training and security training to make sure that security measures that are implemented are also being the procedures are followed. Now, I'm not done. Let me show the next slide. We continue. An individual must be not personally, but must be named to be responsible for oversight and implementation. And in GDPR, you have very often, of course, the data protection officer that oversees and mostly guides the company and provides advice on how personal data is collected, if this is legally done, if the consents have been properly written and drafted and provided to data subjects, if data subject rights are being respected. But in HIPAA, there is they go more towards the security part, where it's the person needs to be individually named to have, it's more rather a CISO, right? Like a person that really oversees this implementation of security. Also, the company has to do initial and ongoing risk assessments, and they must implement the security awareness training. And also, this one's interesting because it's mentioned in the GDPR, but not specifically like this harsh, that employees must be disciplined if they fail to comply with policies and procedures. In GDPR, it's a bit more soft, I would say, where individuals can be liable. That is how it's being said. But here it's really like you're disciplined because company has set procedures to protect the data, and we are not messing around. So this is the overall security. And now I put in just a few of the measures that are mentioned that have been opted. Of course, these are also very similar to GDPR. They're very the same, and there's not just a limitation on these. The HIPAA also mentioned, put in all the measures that make sure your data is safe and secure from unauthorized access or disclosure. One of them is I kept this site from the last time from GDPR because actually it's very similar, like have a risk preparation plan. So what is objectively the risk for data to be accessed, lost, or modified unauthorized? And that is the same. That's also the same wording used. Who's responsible for implementation oversight? I added that. And who's trained? Objectively, what's the risk for an encryption key to be hacked? Who can access the data? So do we have access logs? Access logs is a super important one under HIPAA. Access roles and access logs. How strong are the access measures? What's the risk of re-identification of an individual, for example, by linking a data set? And what's the data stored and with who is it shared? And actually this whole linking of data, linking a data set and encryption has also been disclosed by the Federal Trade Commission, that they are really looking into that. Data should, if you say you have anonymous data, then it should be anonymous data. It should not. That's the same as what they're following the DPAs in the EU as well, in the same regards. If it's anonymous, it should be anonymous. You cannot come up later with other linked data set and keep this risk assessment open and ongoing with all the new vendors that you're hiring or all the data that you're sharing. Now, data breaches under GDPR are a bit different than HIPAA, and this is an important one. So this is under GDPR, where I mentioned last time, if you have red flags and it could lead to unauthorized authorized access, even if we don't know yet if it's been accessed, but if there is a high chance that it can be accessed. I can give you an example. So there was a website that had a flaw in the code, and that code led to a potential access of all the users' portals among each other. And they couldn't see if other users actually saw each other's portals or not. But for an amount of time, say like a few hours, maybe 6 hours, there was a potential that users saw each other's user portals or could access. Now, even if we don't know if that actually happened, we don't know if data has been disclosed, and we don't know if actually maybe nothing happened, it had to be notified to the authorities, data subjects had to be notified. And then from the moment you find this out, clock starts ticking, you have 72 hours. And then even if your initial assessment isn't done yet, you have to start a notification, and you report to the data controller if you're the website holder, but you're not the main controller. And then you notify the data subjects. Now, this is definitely different on the HIPAA. The whole HIPAA data breach rule is focused on informing the affected individuals. So the breach must have had happened. There is an unauthorized acquisition, access, use, disclosure, and unless you have demonstrated that there is a low probability that the security of privacy has been compromised. So if you cannot prove that the privacy is not compromised from a person, you have to inform the individuals. You have a data breach. So what is not a data breach? A not data breach is when it's anonymized data, when the data is so encrypted that the individual cannot be re-identified from it anymore, even if you still hold the key, if that key has not been affected. So in a sense, if it was pseudonymized data on the GDPR terms, quasi-identifiers, but the risk for re-identification is absolutely very low, but you have the burden of proof. So if you can prove that people cannot be affected and there is no privacy concern, then you do not need to notify the individuals. And the first most is that you have to notify the individuals. There's also within 60 days. And if more than 500 people, you need to notify the media. So it's a bit of a big thing here. Now, liability is only avoided if you can, as I said, like if you can really show that you have encrypted all of it and you cannot, the privacy is not in concern. All reports of the breaches must be done at least annually to the Human Services, the US Department of Health Services. And another major difference is that fines under GDPR are defined like this. If you are in a violation, you will be in a violation which makes you fall immediately into I will be fined. From that, they look at your previous annual turnover, take a percentage, that is like 4% of your annual turnover, that's the yearly max. From that, there's a day rate calculated from how long you have been like not compliant. And then it's multiplied or divided by 1 to 5, depending on the measures. And measures meaning cooperation with authorities, trying to redeem the fine, other prior risk assessment, etc. So a lot of measures that then can redeem your fine, so they start from the top and they go backwards. In HIPAA and US, this works the opposite. So you're fined, or you're fined per violation, per state, per individual, if the states can also have other violations, then you can have a violation on a federal level. You can have also individuals starting separate lawsuits against you for damages on affected harm. So they will need to show then that the data has harmed them, that the data breach has actually harmed them. And then it's again on your burden of proof on how you have protected the data and how this is very minor or low risk the case. Make sure, another thing that is really important about data breaches, make sure that each of the authorities have different rules. So there are state rules on when you have to report data breaches. But so data subjects is within 60 days. The shortest for authorities or state attorneys in the US per state, depending on the state where the breach took place, the shortest state that has the shortest days you need to report it is 15 days. So you're still good. In Europe, wherever you are, it's every agency is following the 72 rule, because that's the regulation on an EU level. Whereas this has also state derogations from it. On the other hand, other organizations, the state attorneys, the DOJ, the health, the HHS, they can all start investigations against you, and they can also criminalize you. And also the fines go from 10K to 250K to 1 year to 10 years in prison. It all depends on personal liability. Was it willful? Have you been intentionally disclosing data? Or was it, mistakes? Could the mistake have been prevented because it was a mistake that I was just cook, I wasn't there today. It's so these are all the same measures. However, the fines and the consequences can be much higher. Yes, I had some freebies on GDPR. I will update them also with HIPAA later this week. And maybe, I think Adrian has some more stuff today.
Absolutely. I will briefly share some slides. I wanted to also ask you one of the questions that I have from someone in the audience that will be watching this later. So they're asking, what do we need to make sure in the context of AI to do right with HIPAA, right? So how do we manage that? And a good example is, for example, many, let's say, medical companies are working a lot with AI, for example, in drug discovery. It's, let's say, a super important domain for them because they can afford to do maybe a few drug trials every year. So they need to research a lot through existing data now to improve their odds, basically, of discovering the next 20 billion drug.
Yeah, for sure. So indeed, it's the same as other HIPAA data. So you are understanding if you are a covered entity or a business associate, you have to follow the authorized use for data. So you start to explain how the data is being used and by what machine. So what does the AI do exactly? And how does the AI safeguard your data? Now, with the new act coming up, there is a lot of additional risk assessments and override abilities, etc. They are going to be required. Under HIPAA, you have the tools, the safeguards, the access logs. You have the similar risk assessment. Have to explain how the AI works, so to say. So you have an unambiguous consent. Also, that's the same requirement. And then same for consumer for the FCT. It's like for FTC, it's like you don't want to have an unfair, deceptive practice, right? So you want to make sure it's maybe layered if it's unclear, if it's a lot of information you have about your AI system on different data points that are coming back in time, then layer it. Make sure you have the key points so that people understand, the ones that need to understand what you're doing, and make sure that you can respect the individual's rights in this as well.
You were mentioning that you're doing some studies now regarding AI compliance. Do you want to tell us a little bit what's coming? So how can you help companies actually in this space?
Yeah. So I'm indeed going a little bit into the whole AI law from a certification perspective, and I think what's going to how I can help out is with the new EU AI Act that is going to be really important in January, because then it starts to be enforced. It's already enforced for prohibited machines, but then it starts to be enforced for most of the machines that have a high risk. So we need then risk assessments, we need policies, we need things in place. And like GDPR, it sounded a bit like a hype, but fines were happening. And in GDPR, they started a bit slower. Now we're starting to get a lot of fines, and many of them. Some of the protection authorities in member states are also combining the AI office, because that's another enforcement office that need to be done. So we need to make sure that policies and documentations are aligned. Same as clients that I have that are in an AI medical device. Policies need to be aligned, risk assessments need to be aligned. We have everything in place for the data. Now we're missing that part on the AI. So yes, that now people. I see it in the last few months before the next year. Authorities start to ask questions. They start to send the MDR standing out questionnaires of like, how are you prepared for the next EU AI Act? You have an AI machine. It's like, yes, getting there. So yes, that's if you have any questions about that, connect with me on LinkedIn as well, and I'm happy to update you as soon as I have the full roller coaster on. Yeah,
it's going to be super useful. What we're seeing in the data domain is that there's definitely some lag in larger companies, but it's not necessarily due to lack of willingness, but due to lack of ability, I would say.
Yeah, it's just again an overload of information and too little actual documentation, or like, okay, what exactly do I need to do then? So is this privacy notice okay or not okay? And that's what I'm trying to overcome with with some help and consultancy and some courses and documents. Yeah.
Okay, so I will share a few slides. I think those were, we don't have any more questions right now. Most people will be watching asynchronously a bit later. So I hope I don't bore you for these following couple of minutes, but here I go. So they're not very technical. There is a linked demo in here. So just, mentioning about our library, DLT is very well suited for handling PII data. And you can find a demo in here with code, which is kind of like a cheat sheet. So you can just copy paste and use it in your projects. And we have DLT Plus, which is a commercial offering, and we have some early versions of compliance products. So one is essentially a set of features for searching and securing PII, so monitoring, alerting, detection, and data contracts. And the second is auditing and documenting. So basically generating some of the required documentation, creating wizards to collect all the required data so we actually have it when the authorities come knocking. And something new that we've been working on is something that we call a governed data pond, which is essentially what, let's say, software development was struggling with 10 years ago. And in data, we still haven't solved, which is the local development experience. And what we're proposing here for an early product that we're working on is essentially a local development environment that is fully governed, complete with policies, with knowing what kind of data you're dealing with, if it's PII, who has access to it, who can read it, what can we do with it, can we send it to a machine or not? And of course, once we've actually done development with this, easily having it accepted back into production in a governed way, so meaning also declaring what type of data it is and so on. So if any of you watching have interest in any of these products, just reach out. We are very glad to develop them together with you. Thank you. And that was it for our slides. What we are also doing is we're improving our healthcare vertical support. So we have some larger customers in this space, and they're telling us about some standards, my apology, fast healthcare interoperability resources, and the common data model, OP, sorry. So we are interested to work on both of these standards. I think we already support the first one out of the box. And for the second one, we can do a little bit more. So again, if anyone's interested in a design partnership, just get in touch with us. So thank you, everyone. And let me get rid of these slides. And thank you, Steffi. And let's see how many of our audience are interested in AI. We definitely are. I'm not sure on the exact timeline, but it sounds really interesting.
Yeah, well, stay tuned. Maybe we see each other again. If the audience comes up with new ideas, we're happy to provide the demand.
Thank you very much, Steffi. Have a beautiful day.
Bye. Thank you.